Thank you very much, Daniela. Hi, everyone. Thanks for joining us. My name's Emma Summerfield. I'm a partner in the healthcare litigation team in our Harrogate office. And I'm speaking to you today with my colleague, Vicky Rowlands, who's an associate in the same team. And we're going to speak to you about disclosure in clinical negligence claims, looking at when and how to disclose information. We appreciate disclosure is a bit of a dry topic, so we're going to probably spend about half an hour running through all of the key points that we see come up in cases regularly and that we thought it would be useful to go over with you. And then we're happy to take any questions either through the chat or through you unmuting at that point and asking us. So what are we going to cover today then? We're going to look at standard disclosure, so what it is and what has to be disclosed, the timing of disclosure, so when we should be disclosing documents and what exactly counts as a document. We're also then going to explain about lists of documents and what they need to include, and consider what documents are privileged and therefore don't need to be disclosed. Finally, we're going to look at some examples of disclosure issues that have arisen in our cases and how they were impacted. As I said, the plan is for all of this to take about half an hour, which will leave plenty of time for questions, which we're happy to address at the end. So to get started, standard disclosure then, I've put on the slide what the CPR says about standard disclosure, and under the CPR, parties are required to disclose documents which are relied on by that party, adversely affect that party's case, adversely affect another party's case, or support another party's case. So I think the important thing to remember there is that it's not just documents that assist our case, but it's anything that's relevant to the case and which isn't covered by privilege, which Vicky's going to talk to you about later. So if we break that down a bit further, what is a document? So CPR 31.4 describes it as anything in which information of any description is recorded. I've put some examples on the slides, but it can include emails, letters, drafts, memos, meeting notes, investigation documents, complaint files. It really is a long list of things that can be included, and that's not an exhaustive list, but just some examples for you. It includes electronic information which is not readily accessible. And one of the things that we often find is that whilst the medical records might mostly be in one place, there might be some that are in a different system or not easily located, and it's just being aware of that. So from a trust's perspective, it's ensuring that all of the systems are checked, including all electronic systems. And it's often helpful if you're working in the legal services department at a trust or you're getting involved in the exercise of disclosure to be aware of where different documents could be stored. So just a couple of examples I've come across recently. One was ICU records, and the first 24 hours that the patient was on ICU was a different chart that was handwritten and not kept as part of the electronic record. So until I was made aware of that, we kind of thought there were missing records, but they were just stored in another place. And another example that we've seen quite a few times on cases is that physiotherapy records can often be kept separately as well. Now, I'm sure they are not the only two examples, but I just thought it would give you a flavour of the fact that even things that we think would just be within the medical record can sometimes be stored separately. The other thing I wanted to highlight at this stage is that drafts are disclosable. For example, the whole investigation or complaint file is disclosable, not just the finalised document. So that can include any emails discussing it internally. So if you're seeking comments from members of staff or asking for their input on drafts, that is all disclosable. It's statements prepared as part of the process and draft documents that have then subsequently been amended. So just bear in mind that all of those will form part of what's disclosable in a claim, unless they can be said to attract privilege, which Vicky, as I said, we'll talk about later. We'll also look at some examples towards the end of the webinar of where not disclosing everything has been problematic for the case. So I think the take home from that is just being aware of everything that there is. And if you're the person providing disclosure to the claimant solicitors or to us, just being aware of what needs to be disclosed. And if we or another panel firm are instructed on your behalf and you're not sure whether something should be disclosed, then please just get in touch and ask us, and we'd be happy to guide on that. The timing of disclosure then, I think I'm going to just touch on it briefly because Vicky will go through each of these with you in more detail, but the main thing to highlight is that parties have an ongoing duty of disclosure. So to touch on it briefly, before legal proceedings are commenced, this can include requests for records, investigation documents, trust protocols. It's also important to mention that disclosure is covered as part of the pre-action protocol, so parties are expected to engage in that exercise. The ongoing duty of disclosure continues once legal proceedings have been commenced, and if disclosure isn't received, parties can make applications for specific disclosure under CPR 31.17, as highlighted on the slide. If an application is made, the court will consider whether the documents sought support or affect either party's case, and whether disclosure is required to dispose of the claim fairly or save costs. I will leave time in there because I know Vicky's going to go over those points with you in some more detail. So Vicky, I'll pass over to you.
Thanks, Emma. Yeah, so as Emma said, what I'll do is now go through the points that Emma's just touched on just in a bit more detail. So looking at disclosure before legal proceedings have been commenced, usually the first step by a claimant solicitor in any investigation is to get the medical records. So what will usually happen is either the legal services team or the medical records department within a trust or a practice manager at a GP surgery or similar in a non-trust or GP organisation will get a request for the medical records with a form of authority that's been signed by the patient, or you might find that it's been signed by the patient's representative or a relative if the patient themselves doesn't have capacity. Sometimes those requests might just be a blanket request for all records, and sometimes, usually more helpfully if claimant solicitors do this, is it might be a bit more specific in terms of time periods, although we appreciate that that's not always possible, and sometimes claimant solicitors are quite they are asking for all of the medical records because that is what they need. Check what the request is actually for. So is it just a request for medical records, or is it a request for other documents as well? So as Emma touched on, claimant solicitors might be asking for copies of internal policies, complaint documents, investigation documents, things like that. So do just make sure that if you are dealing with a disclosure request, you are providing everything that has been asked for. If a claim is in proceedings, but we're still at this pre-action stage, so before court proceedings have been issued, at some stage your indemnity provider will likely instruct solicitors, and that's when firms like Hempsons become involved. So if you do have NHS resolution indemnity, that's when one of the panel firms becomes involved. Whilst we would usually ask for the records from the claimant's solicitor, because at that stage we'd hope that they had a nice sorted and paginated set for us to work from, sometimes we do need to come to you for disclosure, whether it's that the claimant solicitors don't have a full set of records and we think they are needed, or there might be additional documents that we need to see that the claimant hasn't asked for. You are able to disclose the records to your solicitors without that form of authority from the claimant. So if you disclose them to the claimant solicitors, you will need a form of authority signed by the patient or a suitable representative. But if you disclose them to your solicitors, you don't need that form of authority. You can just send them straight to us. If you're an individual GP or clinician who's been named as a defendant, so the claim is against you personally rather than against the practice or the organisation, you can access and provide to your solicitor any records if you're still working at the same practice or organisation and you have access to those records as part of your job. If you were ever to receive a request from a patient directly for medical records, we'd recommend that that's passed on to your practice manager or somebody else within the organisation that deals with medical records. But again, you can disclose them to your solicitors, and we'll cover on the next slide what happens in the situation where you're no longer employed at the same practice or organisation. So if you're working within a medical records department or a legal services department, you might find that you're asked to disclose records to witnesses. If you're an individual GP named as a defendant, you might need to access records from a previous practice or organisation if you're no longer working there. So we set out on the slide there's just some general guidance surrounding that. So I'll just go through it in a bit more detail with you. So first of all, looking at trusts or other non-GP medical organisations, if you are a legal services manager at a trust or another organisation, if the clinician is still employed, there is no issue with you disclosing the records directly to them. They should actually have access if they're still working for you, but as Emma said, there's often so many different medical records systems that it's sometimes quite helpful for you to put together the records that you need them to review, because it helps them locate what they need to review and comment on, so you can send them to them directly. In the case where a clinician has left the trust or the organisation, we do need to be careful in respect of patient confidentiality. So in that situation, what we'd recommend is asking your solicitors to disclose the records to that witness or clinician for them to review and comment on. A similar situation arises if you're a practice manager and the practice is named as a defendant. If we as your solicitors ask for comments from a member of staff, whether that's a nurse practitioner or a GP, again, you can let them have a copy of the records and they should have access anyway. If we need comments from somebody who's left the practice, again, the best way to do that is to let your solicitors have the records and we can pass them on to the factual witness for you. If you're a GP who's been named personally as a defendant and you are still employed at the same practice, obviously you'll have access to the patient's medical records to review those yourself. If you're a GP who is named personally as a defendant and you have left the practice where the patient's registered, or similarly if you're a clinician and you've left the organisation, you should wait for the records to come via your solicitor. Please don't go to a previous employer and ask them to disclose the records directly to you. And similarly, if you are a practice manager or somebody else employed at a trust or organisation that deals with disclosure, if you do receive this kind of request from someone who is a witness in a clinical negligence case, you shouldn't be disclosing the records directly to them. We would always recommend that they go through a solicitor. So the thing to always remember as well is if you have been provided with records as a factual witness, or you're sending records to a factual witness for them to review in order to assist with investigations, make sure that they're stored safely and confidentially. A lot of the time, firms like ourselves, we use encrypted systems like egress, so the records are always sent confidentially. They're then stored confidentially on that platform, but obviously if they are then downloaded, we need to be making sure that they are saved somewhere confidentially and securely, and then at the end of a case advising that witness to make sure that they are confidentially destroyed, because we just need to be aware of patient confidentiality. So that covers what happens in the pre-action stage. So once legal proceedings have been commenced, really it's the same rules in terms of who you're disclosing to and what authority you've got to disclose. The only additional thing to note is at this stage, and it might have happened earlier on, is that if solicitors have been formally appointed to act for you, the claimant's solicitors shouldn't be contacting you directly anymore. They should be contacting your solicitors. So if you do receive any further requests for disclosure, once you've got solicitors instructed on your behalf, please do pass that on to your solicitors so that we're aware of what's happening, and the records should be disclosed via your solicitor as well. There shouldn't be any disclosure happening directly anymore. Emma also just touched briefly on applications for specific disclosure, so I'll just go through this with you in a little more detail. So if there are documents that a claimant is entitled to see, they've been requested and not disclosed, they can make an application to the court to essentially force disclosure. So long as those are documents that the claimant is entitled to see. Emma again mentioned earlier, just touched on privilege, and we'll go into that in a bit more detail later on. The same also applies to us. So if we know that the claimant's got documents that we're entitled to see, but we can't access directly without their explicit consent, we can make an application to court as well. So we've talked today about accessing records if you are the defendant, but obviously sometimes we need to see records from other healthcare providers as well, which we don't have access to without a signed form of authority from the claimant's solicitor or disclosure from the claimant directly. So whilst the claimant can make an application for disclosure against a trust or another medical organisation, equally we can do that as well on your behalf if we need to. There are criteria that have to be met for those kind of applications to be made, and those are set out in the civil procedure rules. But essentially, the person making the application must be able to show that that document is required for them to investigate the claim and that it isn't privileged. And like I say, we'll come on to privilege a little later. There can be cost consequences if an unnecessary application has to be made. So the court may consider an application was unnecessary, for example, if a request was made by the claimant and simply not acted upon, or they've been sent part of what they requested. An example of that might be that they've asked for records from a GP surgery and they've been provided with the computerised records, but not a copy of the correspondence that's been copied to the GP surgery. We do appreciate that sometimes investigating disclosure requests can take time. So if we can show that the request is being acted upon and for various reasons it's taken time to disclose, that's absolutely fine. Like I say, an example of when an application might be made is if a request's been received and just simply not acted upon. If a claimant is successful with an application for disclosure, obviously those documents do then need to be disclosed, but there are also consequences as well. So the defendant could be ordered to pay the claimant's costs of making the application and attending the hearing. It's also worth noting that a court can make an adverse inference if a document has been requested several times and not disclosed without good reason. What that means is if the case were to ever reach a trial and the document has not been provided, the court could infer that there's something within that document that's detrimental to the defendant's case. That might not be the case at all, but if we're not able to demonstrate a good reason for failing to disclose document that's being requested, it is open to the court to make those adverse inferences. So that's just something to be aware of, just highlighting why disclosure in these cases is so important. I'm just going to pass back to Emma now and she'll explain what happens to you in terms of disclosure as part of the court proceedings and what the formal steps are.
Thanks, Vicky. So yes, as Vicky mentioned, once we're on a formal court timetable, a lot of you may well know that usually the first step following a directions order being put in place by the court is disclosure of documents. And that's effectively done early in the process of litigation to make sure that the parties have all of the documents that are required to fully investigate the claim. That process of disclosure at that stage is often referred to as a list of documents because in effect that is the court form, which is a standard form that we would complete on behalf of the defendant and which claimant solicitors will complete on behalf of the claimant. As I said, it's a standard form which we'll complete on the defendant's behalf and ask them to sign. The important things about the list of documents to mention really are that it must contain all of the documents held that relate to the case, whether they are supportive or not. So it's kind of what I mentioned before about thinking about what a document is. But for example, it can be the medical records, complaint documents, investigation documents, trust protocols, etc. We also have to set out what documents we hold, but we're not disclosing because they are privileged. And I feel like we've said this a lot, but Vicky is going to explain what privileged documents are to you shortly. Generally, we will look through all of our files at this stage that we have relevant to the case, and we will pull out all of the documents that you have provided to us, that we've received as copies from the other side, and we'll consider everything that we've got, and then we'll put that onto the list of documents and send it across to the Trust Legal Services team, the GP, the practice manager, etc., for them to sign it. I do want to highlight that by signing that list of documents, and it's not meant as a worrying thing, but that is to say that appropriate and accurate searches have been carried out to look for documents and to locate them. And that's why earlier I wanted to highlight the importance of knowing where different documents are held and making sure those systems are checked. So Vicky talked about pre-action disclosure, and a lot of documents are disclosed at that pre-action stage. So we, or the claimant or the claimant's solicitor, may well have asked, most likely will have asked for sight of some documents earlier in the case. But at this stage, it's important that a further full search is carried out. So all of the electronic systems where medical records are held. And as I mentioned, that's not just the clinical entries themselves, but any other information which can be extracted from electronic systems that sometimes run in the background. So I had a case where what was printed as part of the documents was just the first page of something, but actually on the system, it was a dynamic document that had multiple pages, and that had to be screenshot to provide disclosure. So if there's any quirks like that you're aware of, or that witnesses tell us about when they're discussing the cases with us, we will highlight them, but also do feel free to ask us about it and to highlight things to us as well. Once the list has been completed and signed, that's then exchanged with the other side or the other parties if there's multiple, and requests are made for sight of any items on the list. We then have, as solicitors, either 7 or 14 days, usually, depending on what's been agreed in the directions, to disclose all of those documents. So what you'll often find is that we want to make sure we have all of those documents available and to hand at the time of including them on the list of documents, if we've not already had them before, just so we don't come up against any difficulties when it comes to having to disclose them and comply with those court directions. I mentioned that as well as the documents that we do have to disclose, we would include documents that we held but were not willing to disclose because they attracted privilege. And Vicky's going to just explain what we mean by privilege and what that applies to now.
Thanks, Emma. Yeah, we've mentioned privilege a few times, but it was about dropping it into the presentation in the best possible place. So we have kind of left it to the end, but there has been mention of it obviously all the way through, but it's an important concept. So like I say, we've touched briefly on it, but there are some exceptions to full disclosure, and that's what we refer to as privilege. Due to the time restraints of today, we're not going to provide you with an in-depth analysis of the rules on privilege. We're going to just set out the main principles. So there's two types of privilege. The first we refer to as legal advice privilege, and that includes any correspondence between you as the client and your solicitors or with your indemnity provider in relation to the claim. So correspondence that's been exchanged between us as part of the claim will not be disclosable to the claimant's solicitors. They're not entitled to see any of that. And the point to bear in mind when you're looking at whether or not something does attach legal advice privilege is, was the document created for the purpose of giving or receiving legal advice? And if that's the case, then the document won't be disclosable. The other exception is litigation privilege. So those arguments tend to arise when we seek to say that documents were prepared in contemplation of legal proceedings arising out of the incident. So as you can appreciate, that one's obviously a little bit more of a grey area sometimes, and it's not always black and white. But an example would be any internal assessments or investigations that have taken place following notification of the claim. But it's also worth highlighting that if we want to run this argument, we have to say that the litigation is the dominant purpose for which the document was prepared. So if a claimant's solicitor gets in touch and suggests that there is going to be a claim, but there was already a SUI investigation underway, for example, it wouldn't necessarily mean that any SUI documentation generated or produced after that point would then attract privilege. We have to be able to argue that the dominant purpose for the document being prepared was the litigation. So a good example of this is emails from clinicians. So if there's any internal correspondence relating to the claimant's treatment, that will be disclosable because the dominant purpose isn't litigation. The dominant purpose is to discuss the treatment. However, any comments that clinician then may have made in writing regarding the claimant's treatment, but for example, commenting on the allegations made in a letter of claim or in court documents, that will not be disclosable because the only reason the clinicians prepared that document is to comment on the allegations that are being made, and therefore the dominant purpose is the litigation. As I say, litigation privilege is often a little bit more of a grey area. Sometimes documents, it's not black and white whether or not something should be disclosed. And so what we would say is that the best thing to do is, if you're unsure, is give everything to your solicitors, and we can advise you on whether or not that document is disclosable, if it needs to be disclosed to the claimant pre-action, or, as Emma said, if it needs to be included in the list of documents as well. We could probably spend another hour going through various examples of whether or not something's protected by litigation privilege. But like I say, we'd say the overarching advice is send it to your solicitor if you're not sure, and we can look at it on a case-by-case basis, and advise whether or not it's something that should be disclosed. We realise we've been through quite a lot of things in principle, but what me and Emma thought might be helpful now is if we just run through a few real life examples that we've both come across, just to put all of that in some context for you. So I'll pass back to Emma to go through the first couple of examples with you.
Thanks, Vicky. So yes, as Vicky said, we just thought it would be helpful for you to understand how these principles can affect cases on a day-to-day basis. So the first example I wanted to mention was a clinical case where the claimant had attended A&E on multiple occasions. The care she was provided in A&E was criticised, but we disclosed records from her first and second attendance when we were asked for records. And then 2 years later, we disclosed records for a third attendance. The records for that third attendance were stored on a separate system, and disclosure only took place sometime later. As I said, it was, a couple of years later when the case was continuing to proceed, that those documents were disclosed. So the claimant then amended her case to say there had been a fourth attendance and she had been discharged from hospital inappropriately. And we had no record of that fourth attendance as well as the defendant. So the trust didn't have any record that they could provide to us of that attendance. Now, the difficulty we faced in this case was that because it took so long for the records relating to the third attendance to be disclosed, it affected the defendant's credibility when pleading there was no fourth attendance and therefore no records. And you can understand how that can come to light, because the claimant's just thinking, well, they're stored somewhere else. It took you 2 years to disclose the third attendance, so this is probably somewhere. But in this case, the district judge did side with the claimant, and it was an issue at an interim hearing at this stage. So the district judge did say it would ultimately be a matter for the trial judge on conclusion of the case if the case went to trial, but that he himself wasn't convinced that the trust didn't have those records and that sufficient searches had been conducted. So that's just highlighting a difficulty that arose because of slow disclosure of earlier attendances when trying to then plead that another attendance hadn't happened. Now, those sorts of factual discrepancies happen quite a lot, and it may have been a different position, a different argument, stronger argument we could have put forward if full disclosure had taken place earlier and we could be confident that all of the documents had been disclosed and therefore there were no other documents relating to a fourth attendance. So that's just picking up on the issues that we highlighted previously of being sure, well, making sure that we've checked as many of the systems as we can to make sure where documents are held. And I think if it's not clear whether documents are held, asking one of the clinicians that work in that department. So my ICU example earlier, that came to light when I was speaking to one of the ICU sisters, and she was able to say, oh, that first handwritten one, we keep that here. So if you're not sure whether something exists and you're working kind of within the legal services department, asking those medics involved in those departments can be a useful way just to make sure we know of all of the documents and systems that might exist. My second example then, this is a case where the claimant had made a complaint before bringing a legal claim. So quite a common scenario. They weren't happy with the treatment provided and they'd written into the trust to complain about that. This case related to a spinal abscess and again, the A&E care provided. In the complaint response, the A&E clinician accepted or seemed to accept causation. So he was effectively saying in the complaint response that earlier treatment would have given a better outcome to the claimant. Now, that was a difficult thing for us to overcome in the complaint response, because whilst the claim was defensible based on expert evidence, it caused issues as that A&E expert was commenting outside of his area of expertise and the complaint documentation was disclosable. So whilst we fully acknowledge the need to be open and honest and the duty of candour, it can be helpful to just make sure that your clinicians know about the need to focus on obviously the care provided and potentially not stray into those areas that might form part of a legal claim, such as causation, that would be for other disciplines to comment on. So just a reminder really that complaints documentation is disclosable. And as I mentioned earlier, that includes any drafts and internal communications about it. So if clinicians are providing comments as part of the complaints process, it's useful to just make sure these address the issues in the complaint and don't stray into areas that they're not really qualified to comment on. That's a couple of examples from me, and I think Vicky's going to now take you through another couple as well.
Yeah, thanks, Emma. So a third example that we've got for you, one of the key medical entries had a handwritten note alongside it, and the claimant alleged that this had been amended at a later date. We could only challenge that through factual evidence, so finding the clinician who'd made the note and taking a witness statement from them as to what had happened. Now, what we appreciate that is if a clinician is contacted as a witness, they see so many patients day in, day out, that if we're asking about a handwritten note that they made 4 or 5 years ago, they might not necessarily remember. So had the original medical notes been available, whilst it might not have been definitive, it might have shown, for example, whether the same pen had been used, was it the same colour, things like that. So what we always say is, where possible, retain the original records, even if they've been scanned into an electronic system. We appreciate that's not possible because hindsight, a lot of trusts now scanning the handwritten notes and then the originals are destroyed. But if a claim is indicated and you do receive an indication of a claim, what should be happening is that any original records that are retained are not destroyed until conclusion of the claim. And that's just an example of where having the original medical records might have been helpful. So we do say that once a claim has been indicated, if it's possible, try and make sure that original records aren't destroyed. And then the last example that we have, this comes back to the point Emma was making earlier about dynamic records. So the disclosure of records in this case had included a screen print of a record for recording results in an ITU setting. It's very similar to Emma's 2 examples earlier, but it is actually a separate case. So the case proceeded on the basis of the print screen document that we had. Shortly before the trial, a new clinician became involved to assist with a discrete point. So we do try to speak with the clinicians involved in a case as early as possible. But for various reasons, in this particular case, a discrete point arose later and we needed to speak with somebody else. He advised that the record was in fact dynamic, so you could click on each result and access more information. By doing that, we were able to find vital evidence that sat behind that initial screen, and the evidence actually acted in the defendant's favour. But that then obviously raised some cost issues, because there had been issues in dispute that might have been capable of earlier resolution if we had disclosed this information that it did transpire we had access to. So that's just a reminder that extracting data from dynamic systems is absolutely critical. So in this case, it hinged on a key period and the blood results at the time. We're able to ask the question of whether or not a particular record is dynamic, but from a print screen, it's not always obvious to us. So if you are getting involved as a clinician and you do know that a system is dynamic, or there's other records available by following systems through, if you can flag that to us as early as possible, because there could be additional information sat behind those initial screens that is important and does need to be disclosed. So that's just a reminder of the point Emma raised earlier about dynamic systems. They were the examples that we had. We appreciate that's been a little bit of a whistle-stop tour about the key principles when it comes to disclosure. So me and Emma are happy to take any questions that anybody might have. Sure, I'll take that one. So if a patient has passed away, you'd usually expect the request for medical records to be coming from whoever it is who is maybe executor of the will, or who has letters of administration. So where there isn't a will and they've had to go and get letters of administration instead. Obviously, we appreciate that that's not always the case. Some people haven't left a will, and medical records might be being requested at a time before letters of administration have been received. You would normally expect it to be a close relative, so a widow, son, or a daughter. If it's any more less closely related than that, you might be wanting to ask questions just to make sure that they do actually have the necessary authority to disclose the records, but that's really probably on a case-by-case basis.
Yeah, thank you. I think it can really depend. It depends how cooperative people are being with disclosure. Sometimes we might have to make an application for specific disclosure of a party's or of a claimant's GP records if we're acting for the trust and they won't disclose those to us or agree to give us those. And that sort of thing can often happen a bit more where you have a litigant in person as a claimant as well, who doesn't necessarily understand the process and why they need to disclose documents. So an application could have to be made on that basis. I had one on a case where we really needed the claimant's education records. It was a child who'd suffered a brain injury, and we needed to know how that had impacted her education to look at then loss of earnings in the future. And the claimant's solicitor just was really, really slow at engaging with us and being willing to disclose. And in the end, we made an application because the documents were needed to progress the case and to be provided to our experts. So there's no specific things that often come up in applications for specific disclosure. It really is a case-by-case basis. But hopefully there are a couple of examples for you. Daniela, I know the next question's what is an SUI? And I know someone else has already responded to that in the chat, but just to confirm, sorry for the abbreviations on our part, but that's a serious untoward incident. And we're basically just referring to any investigations that the trust have done. So themselves, when an incident's been kind of happened and the trust have undertaken a full investigation themselves. That's what we were referring to by those documents.
I think it's my turn. Emma did the last one. So I'm assuming by TP solicitors you mean third-party solicitors. So if the documents have already been disclosed to a third-party solicitor, the chances are your solicitors have got them as well. I think if you've got a list of the record systems that have been checked and you know that the medical records from those systems have been disclosed, we don't have to itemize each entry in the records or anything like that. We can just say medical records from X system. So if you know that they've been disclosed from that system, then we can put that on the list of documents and then that can be signed. And it's worth saying that the list of documents isn't a list of documents that have already been disclosed. It's a list of documents that we hold. So it might be that the documents listed on that document we haven't actually sent to the third-party solicitors yet, and then they are then able to request them. So it's the list of documents is a list of everything that we hold, not necessarily a list of everything that's already been disclosed. I think that answers the question.
No, I mean, I think the easy answer to that is litigation privilege is just what it is. If documents, if the dominant purpose of those documents coming into existence was for the purposes of litigation, then they are tracked privilege and are not disclosable. And the rules that Vicky kind of ran through apply across the board on all of the cases. Yes. Is the short answer to that one. The search when we're doing the list of documents should be everything at the point that the list of documents is being signed. So we appreciate that requests for updated records come in intermittently. So at the point of you doing the list of documents, it might be some time since the claimant solicitors requested updated records. But like I said, we can say that we've got medical records held on X system and then we can give a date range if necessary.
it might be helpful if you do flag at that point, if you can see that you've not had a request for updated records for some time, just flag that to your solicitors, because yes, it might be that we need to see those as well. But yeah, the short answer is yes, the list of documents should include everything that you hold at the point that the list is being signed.
Thanks, Megan. I saw your question. I wasn't looking forward to that because we don't really do any employers' liability stuff, or at least Vicky and I don't. I wouldn't want to constantly tell you what does and doesn't need to be disclosed as part of that. Obviously, if it's documents that are with the solicitor discussing that employment claim, then that would attract privilege in the same way privilege applies, not just in clinical negligence claims, but generally. But unless Vicky wants to add anything, I'm not sure. Sorry, Megan, that I feel confident adding any more detail to that specific question.
No, I think I agree with you, Emma, that we do quite specific litigation work. Legal advice and litigation privilege applies across all litigation, but as I said when I was going through it, the specifics of whether or not a particular document is disclosable, if you're not sure, the best thing to do is to speak to your solicitor who's acting for you. So, in an employer's liability claim, that wouldn't be me or Emma, so we wouldn't be in a position to give you specific advice on a specific document. I think if a request coming from a claimant's solicitor, then yes, the claimant's solicitor does have a professional duty to make sure that the person who they're acting on behalf of has the necessary authority. So a claimant's solicitor shouldn't be acting for a relative who doesn't have permission to bring the claim on that patient's behalf or on behalf of a deceased patient. They do have a professional duty. So unless Emma disagrees with me, I don't think there would be any issue in disclosing. The claimant's list has got a professional duty to make sure that they're only asking for records in the appropriate circumstances.
Yeah, I totally agree. I think that those checks are for the claimant solicitor to make to ensure that they're acting on behalf of the right people. And if you, as a trust or a GP practice or an organisation, get a signed form of authority sent to you from a claimant solicitor, I would feel confident in disclosing the records to them. And Daniela will just pick up on the second part of the question as well, which is what checks should legal teams be doing before they provide records if they get a request purportedly pursuant to the pre-action protocol, if the claim has been brought by someone other than the patient, for example, claiming to be a family member, a partner, or if the patient is a teenager, has died, etc. And I think that's picking back on what Vicky said earlier about who is entitled to request records, particularly on behalf of the deceased. So I won't repeat that. But if it's a child, then they will likely they'll need to have a litigation friend. That's often a parent, and the parents would be able to request records for a child. But I think it's just taking a sensible approach to each request. If it's a distant relative, then yes, I'd be cautious about doing that. If the request's from the claimant solicitor, it's likely that they've gone through those checks that we mentioned earlier. But otherwise, I'd be cautious unless you've got clear documentation as to who they are. So we're not going to disclose records to someone's friend, but if it's the mother of a child, then that's probably okay. I don't know if you've got any more specific examples to add to that, Vicky.
No, I don't think so. I think we've covered everything. This is a question me and Emma have had when we've done this webinar before, and it's not a black and white position when it comes to these documents. We appreciate that clinicians do documents where they reflect on events with certain patients. The principle is that if there is a document with information that relates to a specific patient, then in theory that would be disclosable. But as Robert's highlighted in his question, there are certain exceptions to that, and the approach that me and Emma and other colleagues have taken when this issue has arisen is very much on a case-by-case basis. It will depend on what's in the document, how the patient's referred to, whether or not it is identifiable. There's all sorts of factors. So with that kind of document, we would also always say take legal advice from your solicitor who's acting on your behalf in that case. No, it would depend on the organisation. Even though electronic records are now very much the norm. Most organisations will still have systems for keeping original records, and it would just depend on each individual organisation.
I saw this question come in, so I do know what it related to, so I can mention that. But it was just when Vicky was giving one of her examples about a clinician getting involved in a discrete point, and it was just an issue in the case that had arisen. So it was just a factual point that had happened as part of the claim that we needed a specific clinician to get involved in and tell us kind of their version of events of what happened. So it was just that.
So if you put questions to a clinician due to a request from a claimant solicitor, then that document that they are preparing, so their response, is the sole purpose, the dominant purpose is to comment on the litigation. So it wouldn't be disclosable. And then in terms of asking them to comment on any allegations that are being raised, I know trusts and organisations deal with that differently about how early they want to get the clinicians involved and how detailed they want those comments to be early on. So that would really be an issue for each individual organisation, unless Emma's got anything further to add to that.
No, I don't think so. I think, yeah, that's just kind of depends on the situation and the case and what information's being requested, really. I think that's probably a difficult question to answer without knowing any specific details, really. So not to be difficult, but I am going to pass on that one because that could vary so much depending on what it's about, what the circumstances are, what's included in them. Yeah.
I think it's probably just worth saying that certain documents that disclose, we can redact certain information. So when we do disclose documents, it doesn't have to be the full document that's disclosed. Sometimes there are circumstances where it's appropriate to redact information from them. And again, as Emma said, there's so many variables with something like that it would need to be on a case-by-case basis about disclosure or redacting.
So I'm taking from that question and the mention of tribunal that it's potentially not in relation to a clinical negligence claim. What I will say is in clinical negligence claims for disclosing documents between claimants and defendants, that, as we mentioned in this presentation, there's an ongoing duty of disclosure, and certainly by the time we get to list of documents stage, we want to list all of the documents we have available at that stage. There are then further steps in the court timetable where bundles will be prepared, for example, for a trial, and the parties will try and agree what documents need to be included in that bundle. It's often not controversial in clinical negligence claims, and that is something that we're often able to agree on in terms of what documents should be included. If it's not a clinical negligence claim and it's kind of anything outside of that, then I'm afraid that's not something that I know the answer to.
I think that depends on the wording of the request. If the request is for everything, then everything should be disclosed. If it's just a request for incident and complaint documentation relating to a specific incident, then it's fine at that stage to just disclose what they're asking for. But if it's a blanket response, it's a bit like medical records. If they ask for everything, then you should be disclosing everything.
Sorry, so are we saying for the purposes of bringing a claim, can we disclose to the widow? In that situation, I think it's what we were saying before about if the request comes from a claimant solicitor and they're satisfied that that person's appropriate to act, then that's fine. Also, the widow would be next of kin, so it's a relatively close relationship, and disclosure does often occur on that level. If there's not a claim, I don't know. What do you think about that, Vicky?
It's difficult if there's no claim, so you don't have that reliance that claimant solicitor's done everything that they need to do to make sure that that person's entitled to see the records. There's no will, there's no letters of administration. It is difficult because there is an ongoing duty of confidentiality. So I think at that stage, I think you'd need to ask some more questions about why they were being requested. Yeah, I'm just thinking if you were, because if it was like you say, confidentiality continues after someone's death. If my husband went to my GP and asked for my medical records, I'd hope they wouldn't disclose them to him. So yeah, I think if there's no claim, there's no letter of administration, there's no will. I think you need to be asking more questions about why the records are being requested, just to make sure that it's appropriate to disclose them.